Welcome to the Blake Goodman PC Attorneys Podcast. We provide a knowledgeable guide on bankruptcy law in the state of Hawaii so you can stay informed and get the fresh financial start you need. With over 80 years of combined experience in bankruptcy law, at Blake Goodman PC, we're ready to listen and help you get back on your feet. This podcast series is reviewed and approved by founding attorney Blake Goodman.
In this episode, we'll help you understand when and how you can take on new debt while managing your Chapter 13 repayment plan. Filing for Chapter 13 bankruptcy can be a helpful way to get out of overwhelming debt without losing your assets. Taking on new debt during your Chapter 13 plan is not recommended by any means, but there are some circumstances where you have no other choice. In these cases, people wonder if new debt will be allowed, and the answer is yes, but under strict guidelines. For the most part, new debt is not allowed while you are working through your Chapter 13 plan. However, bankruptcy trustees and the court system realize that the plan can take years to pay off, so they make allowances for some debt acquisitions. A bankruptcy attorney can help you understand what new debt you will be able to take on and help you navigate it with your bankruptcy trustee. First, let's review the types of new debt that are allowed during Chapter 13 bankruptcy. For the most part, it is not encouraged for debtors to take on new debt during Chapter 13 bankruptcy. However, certain types of debt are allowed under certain circumstances, so the new debt doesn't interfere with the current repayment plan. The types of debt that can be allowed with permission from your trustee include utility bill debt, grocery debt, medical expenses debt, urgent medical needs, necessary car repairs, some car loans, and some mortgages. Now, let's explore the importance of obtaining pre-approval for new debt during Chapter 13 bankruptcy. In almost all new debt situations, you will need to get permission from your trustee. This permission or pre-approval will not come easily and will only be given for special circumstances limited to debt for everyday life needs. The trustee will also look at how the new debt will impact your current repayment plan in deciding to grant approval. For instance, if your vehicle is broken and needs to be replaced, but you cannot afford a new vehicle, you may be granted authorization to incur new debt for a new vehicle. The trustee will look at how your vehicle gets you to work every day, which allows you to keep paying off your debt. Taking these things into account, your pre-approval will be granted. In the same breath, you will not be pre-approved to replace your reliable car with something expensive and impractical like a sports car. There will be boundaries as to what the new debt will be for. If you want to consider new debt during your Chapter 13 plan, contact a bankruptcy attorney to determine if your request will be reasonable. Next, let's discuss emergency situations and the implications of taking on debt without approval during Chapter 13 bankruptcy. There is an exception to needing pre-approval, and that is in emergency situations. Some situations demand you to take on debt without any chance to get approval from your trustee. An example might be a sudden medical emergency, which requires you to pay for a hospital stay or urgent care visit. In these circumstances, you will have to agree to pay without approval. As soon as you can, you should let your trustee know that you have taken on this debt and under which circumstances. If it was a true emergency, the debt will be granted without consequences. Finally, let's examine the risks of acquiring debt without proper approval during Chapter 13 bankruptcy. Taking on debt without pre-approval can lead to serious consequences affecting your Chapter 13 bankruptcy case. Avoid taking on debt you do not need and consult your bankruptcy attorney if you think taking on new debt is your only option. Some of the consequences include the following. Your bankruptcy case could be dismissed. Taking debt without approval could lead to a complete dismissal of your bankruptcy case, allowing your creditors and collections agencies to start contacting you again and take action. You may be denied debt discharges. If your case is not dismissed, you may be denied your discharge of debts at the end of your Chapter 13 bankruptcy plan. This means that you will be responsible for paying any remaining debt at the end of your case. Your repayment plan may be modified. The repayment plan that you and your bankruptcy attorney came up with and your trustee agreed upon may be modified. This modification could leave you with higher payments or an extension of your plan. And you may face penalties. You may also face penalties such as fines or other punitive actions as a result of your unapproved new debt taken on during your Chapter 13 bankruptcy plan. Remember, make sure your debt acquisitions are handled responsibly with the guidance of our trusted bankruptcy attorneys. If you are considering filing for Chapter 13 bankruptcy or you are working through your Chapter 13 payment plan and need to take on a new debt, let us help. Our Honolulu bankruptcy attorneys at Blake Goodman, PC, have an in-depth understanding of bankruptcy law and can help advocate for your rights during this difficult time. Contact us today and get back on your feet through a Chapter 13 bankruptcy plan. To schedule your free case consultation, call us at 808-556-7833 or visit us online at debtfreehawaii.com.
Thank you for listening to the Blake Goodman PC Attorneys Podcast. Going through bankruptcy can be a difficult and complex situation, but it doesn't have to be if you have us on your side. Your path to financial freedom starts here. Get in touch with the experienced bankruptcy lawyers at Blake Goodman PC Attorney today to explore your options.